The first thing I noticed when I walked into that courtroom was how cold it was. Not the temperature, though the AC was cranked up way too high for April in Phoenix. I mean the feeling. Like all the warmth had been deliberately drained out of the room to remind everyone that this was a place for facts, not feelings. My stepbrother's lawyer had already set up his folders in neat little stacks on the table across from mine. He didn't look up when I came in. Neither did my stepbrother. I sat down, folded my hands in my lap, and reminded myself why I was there. I was there because my father's name deserved better than what had been done to it. My dad was the kind of man who ironed his own shirts on Sunday evenings while watching football. He grew up in Tucson, moved to Phoenix in his late 20s, and spent 31 years building a small but profitable property management company from nothing. He wasn't flashy. He drove a 2014 F-150 until the day he couldn't drive anymore. He kept his financial records in a fireproof safe in the hall closet and updated his will every few years like it was a regular maintenance task, same as getting his oil changed. He was meticulous. That's the word everyone used at his funeral. Meticulous. My mother passed when I was 9. Ovarian cancer, fast and merciless. My dad raised me alone for 4 years before he met a woman named Sylvia at a church fundraiser. Sylvia was warm and easy to talk to, and she made my dad laugh in a way I hadn't heard in years. They married when I was 14. She had a son from her first marriage, Kyle, 2 years older than me. I never called him my brother. He never called me his sister. We existed in the same house the way two weather systems sometimes share the same sky, occasionally overlapping, usually not. Kyle and I were not enemies. I want to be clear about that. For most of our teenage years, we were just indifferent. He had his friends, I had mine. He was loud and social. I was quieter, more like my dad. I went to Arizona State for accounting, then got my CPA license at 24. Kyle bounced between jobs, sales, then real estate, then something vague involving investment consulting that my dad never fully explained to me. Sylvia passed 3 years ago. Heart attack. My dad took it hard. That's when things started to shift. I don't think I noticed it happening at first, because grief does that. It makes everything feel slightly off-center, and you tell yourself that's just what loss does to a family. Kyle started coming around more, calling my dad more, showing up on Saturdays to help with things around the house. I was busy with work. I told myself it was nice that they had each other. My dad was 71. He was in good health, still sharp, still driving himself to his quarterly dermatologist appointments, still doing his Sunday shirt ironing routine. But he was also lonely, and Kyle was filling that space in a way I hadn't thought to. The first sign I should have caught earlier came on a Tuesday in November, 2 years ago. My dad called me to ask if I could recommend a notary. I asked him what for. He said Kyle was helping him streamline some of the business paperwork. I said that sounded fine and gave him a name. I didn't ask follow-up questions. I was in the middle of tax season and I had 17 open client files on my desk. That's the thing I've had to make peace with. I was distracted. And people who want to take advantage of someone count on exactly that. The first time I became genuinely alarmed was 8 months later. My dad called me on a Wednesday afternoon and asked if I knew why his bank had sent him an alert about a large transfer. I drove over that evening. We sat at his kitchen table, the same one we'd eaten at my entire childhood, and he showed me the notification on his phone. $47,000 had been moved from his personal savings account to a joint business account I didn't recognize. My dad looked confused. Not scared, just confused. He said Kyle had explained that it was a consolidation for tax purposes. He said Kyle had walked him through it, and it made sense at the time, but now he couldn't quite remember the reasoning. I'm a CPA. I know what legitimate financial consolidation looks like. That wasn't it. I told my dad I'd look into it. I told him not to do anything else with that account until I had answers. He nodded and offered me the leftover pot roast in the fridge. I took some home and sat at my own kitchen table at 11 o'clock that night, staring at the account statement he'd forwarded me, trying to figure out what I was actually looking at. That night, I made a decision. I was going to be very quiet about this. I was going to watch. Over the next 4 months, I did something I'd never done before in my personal life. I built a file. I'm an accountant. Building files is what I do for a living. I pull records, I trace transactions, I find the number that doesn't match the story. Doing it for clients is one thing. Doing it for your own family is something else entirely. Every evening after work, I would sit at my laptop and go through whatever my dad had forwarded me, cross-referencing dates and amounts. What I found piece by piece was this: 11 separate transfers over 14 months, ranging from $8,000 to $63,000, all moved from my dad's personal and business accounts into accounts that Kyle controlled or co-owned. 3 of those transfers had my dad's digital signature, but when I looked at the timestamps, 2 of them occurred on dates when I knew my dad had been traveling. Once to visit his sister in Albuquerque, once to a college friend's retirement party in San Diego. He wasn't near a computer on those days. I had his travel receipts because I'd helped him book the flights. There was also a change filed with Maricopa County 7 months earlier that had quietly added Kyle's name as a co-owner on one of my dad's 3 rental properties. A property worth, at current market value, somewhere around $410,000. And then there was the document that made my stomach drop. A power of attorney, signed 14 months ago, granting Kyle broad financial authority over my dad's accounts in the event of incapacity or extended absence. It had been notarized. My dad's signature was on it. I called my dad. I asked him if he remembered signing a power of attorney. He said he thought he had signed something, but he thought it was just a backup document in case something happened to him. He said Kyle had explained it was standard estate planning. I asked if I could come see the copy he'd kept. He said he'd look for it. He never found one. I hired an attorney in February. Her name is Patricia Wynn, and she works out of a firm in Scottsdale that specializes in elder financial abuse. I found her through a colleague who had referred a client to her the previous year. When I laid out what I had in her conference room, she was quiet for a long moment. Then she said, "How did you compile all of this?" I told her I was a CPA. She almost smiled. She said, "Okay, then you understand what we're looking at." I did. We filed a civil complaint in March. Fraudulent transfers, breach of fiduciary duty, undue influence in the execution of a power of attorney. We also filed a petition to have the property title change reversed. Kyle was served on a Thursday. I know because my dad called me that afternoon, upset, asking what was going on. I drove over again. I sat with him at that same kitchen table and I explained everything I had found. I showed him the documents. I watched his face as he looked at the dates, at the amounts, at transactions he had no memory of authorizing. He was quiet for a long time. Then he said, I trusted him. I didn't say anything. There was nothing to say. Kyle's response to the lawsuit arrived 3 weeks later, and it contained something I genuinely hadn't anticipated. Attached to his legal response was a letter from a doctor, a physician named Dr. Raymond Oakes, identifying himself as a geriatric specialist. The letter stated that he had evaluated my father over the course of several consultations and had determined that my father showed significant signs of early-stage cognitive decline affecting his memory, judgment, and capacity for complex financial decision-making. The letter said that Kyle had been acting not out of self-interest, but out of concern for an elderly man who was no longer capable of managing his own affairs. The letter said that I, his own daughter, had a history of estrangement from my father and was now attempting to exploit the legal system to gain control of assets I had no rightful claim to. I read that letter 3 times. Then I set it down on my desk and I went to the break room and I stood there for about 4 minutes, not getting coffee, just standing. My father did not have cognitive decline. He forgot where he put his phone sometimes. He occasionally lost track of what day of the week it was. He was 71 years old. Every 71-year-old I'd ever met did those things. But more importantly, I had been having substantive, detailed conversations with my father for the past 4 months. About financial records. About specific transactions. About dates and account numbers and property deeds. He had been clear. He had been present. He had been unmistakably himself. And I had recorded several of those conversations. with his knowledge and permission, because I told him early on that I was building a legal record and I wanted his words documented. I went back to my desk and called Patricia. She listened. Then she said, "Pull everything you have on Dr. Oakes." Dr. First. Raymond Oakes had a medical license in Arizona. He had a practice in Tempe. He had a Yelp page with 11 reviews, most of them vague. He did not appear anywhere in my father's medical records, not his primary care physician's notes, not his insurance claims history, not the patient portal for the hospital system my dad had used for the past decade. I requested my father's complete medical records through proper channels and went through every page. 43 pages of documentation over 8 years. Raymond Oakes' name did not appear once. I pulled the public business registration for Oakes' practice. It had been registered 22 months ago. Kyle had met his current girlfriend 18 months ago. Her name, and I would later confirm this, was Denise Oakes. She was Raymond Oakes' daughter. I sat with that information for about 2 days before I told Patricia. She wasn't surprised. She'd seen this kind of thing before. What she said was, "Now we know what we're dealing with." The hearing was on a Tuesday in April. I wore a gray blazer and the small pearl earrings my mother had left me. I arrived 20 minutes early. I sat at the plaintiff's table next to Patricia, and I kept my hands still in my lap, and I did not look at Kyle. He had a good attorney. That was obvious from the way the man arranged his materials. Unhurried, deliberate, like someone who had done this many times and was comfortable. Kyle sat beside him, looking somewhere between bored and confident. He'd inherited Sylvia's ease in social situations. He knew how to seem like the reasonable person in a room. The judge was a woman named Honorable Diane Caswell. She was somewhere in her 60s. She read through the initial filings without expression, occasionally making small notes on her pad. Kyle's attorney went first. He presented the narrative they had constructed, a devoted stepson who had stepped in when a deteriorating elderly man needed help. He spoke about my estrangement, which consisted of the fact that I lived 20 minutes away and saw my father every 2 to 3 weeks, apparently not enough to qualify as present in Kyle's version of events. He presented Dr. Oakes' letter. He spoke about it at length. He said the word decline 9 times. I counted. When it was Patricia's turn, she stood up and she said very calmly, "Your Honor, we'd like to begin by addressing the medical evaluation at the center of the defense's argument." She asked the judge if she could approach the bench with the document. The judge said yes. Patricia placed a request in front of her, a simple one. She asked the court to compel Dr. Oakes to provide his clinical notes, appointment records, and billing documentation for every consultation he claimed to have conducted with my father. Kyle's attorney objected. Patricia cited the relevant Arizona statute. The judge looked at the document for a moment and said, "I'll allow it." Kyle's attorney said Dr. Oakes was not present and could not be compelled at this time. Patricia said, "We anticipated that. We've issued a subpoena." She paused. Dr. Terment. Oakes was served yesterday morning. Something shifted in the room, a very small shift, but I felt it. Patricia then presented a summary of my father's complete medical records. 8 years, 43 pages. No mention of Raymond Oakes. She presented the registration date for Oakes' practice. She presented the business relationship between Oakes and Kyle's girlfriend. Public record, verifiable. Then she asked if I could approach the bench. The judge said yes. I walked up with a binder I had assembled over the previous 6 weeks. Tab by tab, Patricia walked the judge through it. The 11 transfers, the timestamps, my father's travel receipts for the 2 dates when his digital signature had been used remotely, the phone records showing calls between Kyle and his girlfriend on the same days those transfers occurred, the audio recordings of my conversations with my father. Clear, coherent, detailed, made over a 4-month period. The judge listened. She did not interrupt. When Patricia finished, the judge looked at Kyle's attorney and asked him a question I had not expected her to ask first. She said, "Counsel, can you tell me when Dr. Oakes first examined the plaintiff's father in person?" Kyle's attorney said he would need to confer with his client. The judge said, "Take a moment." Kyle and his attorney had a brief, quiet conversation. I watched without looking like I was watching. I saw Kyle's jaw tighten. I saw his attorney's posture change, just slightly, just enough. His attorney turned back to the bench and said that Dr. Oakes's evaluation had been conducted primarily through remote consultation and review of secondary documentation provided by the family. The judge took off her reading glasses. She set them on the bench in front of her. She looked at Kyle's attorney with an expression that I can only describe as the specific patience of someone who has been doing this for a very long time and has heard a great many things she did not believe. She said, "So Dr. Oakes never examined this man in person. It wasn't a question." Kyle's attorney began to say something about the validity of remote medical evaluation. The judge held up one hand. She said, "I'm going to ask you to stop there." The hearing recessed for 30 minutes. When we came back, the judge issued a ruling on the immediate motions. She vacated the power of attorney on the grounds that the documentation supporting it was insufficient and that there was credible evidence the signatory had not been fully informed of its scope. She ordered a forensic audit of all 11 transfers. She issued a formal referral to the Arizona Medical Board regarding Dr. Oakes's letter and the circumstances of its creation. She granted a temporary freeze on any further changes to the property title. Kyle's attorney asked about the timeline for a full hearing. The judge told him she expected the forensic audit results within 60 days. She told him she also expected Dr. Oakes to appear in person for the next hearing date. She said that last part looking directly at Kyle. He looked down at the table. I called my dad from the parking garage afterward. He picked up on the second ring. I told him what had happened. I kept it simple. I told him the judge had agreed to look at everything and that we'd frozen the accounts and the property transfer. He was quiet for a moment. Then he said, "So it's not over yet." I said, "No, but we're on the right side of it now." He said he'd made chicken soup. He asked if I wanted to come over. I sat in my car for a minute after we hung up. The parking garage was dim and the fluorescent light above my spot was flickering. I was shaking slightly, which I hadn't noticed until then. Not fear, just the body's way of releasing something it's been holding. I drove to my dad's house. We ate soup at the kitchen table, the same one, always the same one. And he told me a story I'd heard before about meeting my mother at a Diamondbacks game in 1991. I didn't stop him. I let him tell the whole thing. The forensic audit took 54 days. It confirmed every transfer I had flagged. It also found 3 additional transactions I had missed. Smaller amounts, harder to trace, but definitively connected to accounts Kyle controlled. The total came to just under $312,000. Dr. Oakes appeared at the second hearing. He came with his own attorney. When the judge asked him to describe in specific detail the in-person consultations he had documented in his letter, he became evasive. He said the evaluation had been comprehensive, but conducted through various modalities. He said he had relied on collateral information provided by a concerned family member. The judge asked him directly, "Did you ever meet this man face to face?" He said, "Not in a traditional clinical sense." The judge asked him what that meant. He said he had reviewed a file Kyle had provided and spoken with him by phone. The judge looked at him for a moment. Then she said, "You wrote a letter diagnosing a man with cognitive decline without ever meeting him, based on a file assembled by the person who stood to benefit financially from that diagnosis." He said he believed the information had been accurate. The judge said, "I'm referring your testimony today to the Arizona Medical Board and to the Maricopa County Attorney's Office. You may step down." The full ruling came down 6 weeks after that. Kyle was ordered to return the $312,000 with interest calculated from the date of each transfer. The property title change was permanently reversed. The court found that the power of attorney had been obtained through undue influence and was void. The judge's written opinion was 12 pages. I read all of it. The language was measured and procedural, the way legal documents always are. But there was one paragraph near the end that I've thought about many times since. She wrote that the evidence presented demonstrated a deliberate and calculated pattern of financial exploitation targeting a vulnerable adult, and that the involvement of a medical professional in manufacturing documentation to support that exploitation represented a serious breach of the public trust that this court views with significant gravity. Kyle filed a notice of appeal. His attorney withdrew from the case 2 weeks later. The appeal was dropped. Dr. Oakes' medical license was suspended pending investigation by the Arizona Medical Board. The Maricopa County Attorney's Office opened a separate criminal inquiry. I don't know where that stands right now. These things move slowly. Kyle eventually repaid a portion of the money before the court enforcement deadline. I think his own attorney, the new one, made clear to him that non-compliance was going to make things significantly worse. The remainder came from the forced sale of an investment account he'd opened in the previous 2 years. My dad got his money back. Not all of it, not perfectly, not without the exhausting grind of legal fees and depositions and waiting, but the number that came back was close enough that his retirement is intact. He still has the rental properties. He still has the house with the kitchen table. The part I think about most isn't the courtroom. It isn't even the ruling. It's a phone call I had with my dad about 6 weeks after everything was finalized. He called me on a Sunday morning, which is unusual for him. Sunday mornings he's usually doing laundry and watching whichever pre-game show is on. He called to tell me he'd gone back to his hall closet and organized the fireproof safe. He said he'd found the original copy of his will, the real one, the one he'd last updated 4 years ago, before any of this. He read me a section of it, slowly, the way you read something you want to make sure the other person actually hears. He had left things the way they had always been. My name was there. The way he'd always intended, he said, I just wanted you to know I found it. I said, thanks, Dad. He said, I'm sorry it took me a while to see what was happening. I told him he didn't have anything to be sorry for. I told him people who do this kind of thing are good at making it invisible. I told him the fact that he listened when I came to him with questions, that he trusted me enough to look at the documents to let me help. That was the whole thing. That was what made it possible to fix. He said, you sound like your mother when you say things like that. I didn't know what to say to that, so I just said, I'll see you Wednesday. He said, I'll have the soup on. I've thought a lot about what I would say if someone asked me what the lesson was. That's the thing people always want at the end of a story like this, the clean takeaway, the single thing to remember, but I don't think it works that way. What I know is that the financial records were there the whole time, the evidence was always there. What it took was someone who knew how to read it, and who was willing to be slow and careful and quiet until the moment it mattered. I know that the people who do this, who target someone's father, someone's mother, someone's grandparent, they count on the family being too busy or too trusting or too uncomfortable to look closely. They count on the assumption that the person in front of a notary understands everything they're signing. I know that if you are a CPA and your father calls you to ask about a large transfer, you should stop what you're doing and drive over that evening. And I know this. The same table has been in my dad's kitchen since 1987. It has a burn mark on one corner from a candle that tipped over at Christmas when I was 7. It has a scratch along the edge that nobody remembers making. Every time I sit at that table, I am 7 years old, and I am 14, and I am the age I am now, all at the same time. That table is still there. So is he. That's the whole thing, really. That's enough. I've thought about what made any of this possible, and the honest answer is uncomfortable. It almost wasn't. There was a version of this story where I was too busy during tax season to drive over and look at that bank alert, where I told myself Kyle was just being helpful, where I let my discomfort with confrontation do what discomfort usually does, talk me into doing nothing. That version exists. It was close. And in that version, my father loses everything quietly, in a way no one could quite prove, and Kyle walks away having never faced a single consequence. The difference between that version and what actually happened wasn't luck. It wasn't some outside force stepping in to balance the scales. It was a choice I made on a Tuesday evening to get in my car and go look at the documents, and then another choice the next morning to start a file, and then 47 more choices over 4 months, each one small, each one unglamorous, pulling records, cross-referencing dates, requesting medical files, reading through 43 pages of my father's help history line by line. What Kyle did to my father was deliberate. It took planning and patience and the calculated willingness to exploit someone who trusted him. That kind of thing doesn't happen by accident, and it doesn't unravel by accident either. It unravels because someone decides to pay attention and refuses to stop. I think about Dr. Oakes sitting in that courtroom, unable to name a single in-person appointment with a man he had diagnosed in writing. I think about what that required of him, not just dishonesty, but a specific confidence that no one would ever check. That's the thing about people who do this. They bet on invisibility. They bet on the assumption that families are too distracted, too trusting, or too afraid of conflict to look closely at what's actually happening. The bet almost worked. What I keep coming back to is this: integrity isn't dramatic. It doesn't announce itself. It's the choice you make at 11 o'clock at night when you're tired and you'd rather not know what the documents say, and you look anyway. It's sitting with information that makes you sick and not letting it make you reckless. It's building your case slowly, carefully, without tipping your hand, because you understand that how you get to the truth matters as much as getting there. My dad raised me to be methodical. He didn't frame it that way. He just ironed his shirts with the same care every Sunday and kept his files organized and updated his will every few years because that's what a responsible person does. I absorbed that without knowing I was absorbing it, and when I needed it, it was there. Kyle had advantages I didn't. He had more time with my dad in those 2 years. He had a doctor willing to put his name on a letter. He had a head start. What he didn't have was the discipline to cover every detail, or the self-awareness to understand that the person most likely to notice was the one who'd been taught, from childhood, to read a financial record the way other people read a story. I'm not telling this because I want credit for it. I'm telling it because someone reading this right now might be the person in my position. The one who got the strange phone call, who noticed the account alert, who has a quiet feeling that something is wrong but doesn't know how to prove it. And I want that person to know the evidence is usually there. It takes patience, and it takes courage, and it takes the willingness to be slow when everything in you wants to react fast. But it's there. My dad still has his house. He still has the table. That's because someone decided to look.